the only way to start your day.
At the City Blue Hotel in Mombasa. And then on the 10th, another one will take place at the Boma Inn in Eldoret. And on the 13th of September, another one will take place at Movenpick Hotel in Nairobi. What am I talking about? I'm talking about the Study Abroad World Fair that takes place courtesy of Cradell. Cradell is the largest study abroad platform in Africa, helping students get matched and enrolled into 575 plus top universities across 50 destinations. It's the most diverse collection of universities available to us Kenyans under one roof. So it's not like traditional study abroad agents where you're going to be asked to, select from just a handful. It's across board and matching your desires and your skills to find the best fit course, university, and study destination. So students get help and support every step of the way with a team of expert counselors. They help students to shortlist universities, secure discounts and partial scholarships for making university applications and securing offer letters very quickly, and assisting in study visa applications and student accommodation. All of that will be happening at this fair where we want you to attend. All right. So what you need to do, you need to get invited. In order to do that, you need to send an email, you need to register on the website www.craydel.com. That's CRAYDEL.com, or call 0799 000 That's 0799 000 And that's what you need to do, and do it today. The first one coming up not too long from now in Mombasa at the City Blue Hotel. Sawa. All right, Dennis, wrap it up as you've been telling us about money this morning.
Yeah, so here's a question where you've created your money, you have protected it. Now, the next course of action is how do you make sure that this money is transferred to those who would continue with your legacy, right? And this is, wealth is more than just money. It's about the legacy and values that you pass on. Now, Standard Chartered Priority Banking is telling you that you will get estate planning to protect what matters and ensure a smooth transfer to the next generation. Now, in a world of constant change, and their team will help you stay prepared, not just reactive. This is about being intentional. It's about lasting wealth built on trust, strategy, and values. Now, begin your journey today by emailing wealth.ke@sc.com, because Standard Chartered Priority Banking says your time for wealth is now.
Indeed, it is. Your time for wealth is now. We're getting into a conversation. More often than not, everybody's on socials at some point, making a comment, reading another, and also just taking into consideration what folks along this Bill Gates internet actually does, right? This morning, Ndong Evans is a constitutional lawyer. Well, not this morning. I assume that he always is. But this morning, we welcome him to the Situation Room. Kiroko Ndegwa, also an advocate, and both of them are here this morning. Gentlemen, good morning.
Good morning. How are you?
I am well, thank you. Karibu sana.
Asante.
Good to have you in the room today. We're going to be looking into conversations around defamation and libel. What can I actually say and get away with it? And what can I actually say and not get away with it? We'll be looking at words can harm, posts can haunt. But before we get into that, let's welcome you to the hot seats of the Situation Room. Dennis is going to share a proverb, as he often does, from a different African country every week. He'll tell you where we are. We'd love to get your interpretation of it.
Yeah, so we are in Morocco today, the winners of Chan. We hoped Kenya would be the winners, but ile kitu ilifanyika. But that notwithstanding, let's talk about Morocco. So Morocco is located northwest Africa, bordered by the Atlantic Ocean, Mediterranean Sea, Algeria, and Western Sahara. Now, the Strait of Gibraltar separates Morocco from Spain by just 13 kilometers at its narrowest point. So if you want to get to Europe, it's just 13 kilometers if you want to get there. But let's go to the proverb today. He who doesn't have honey says it's bitter. He who doesn't have honey says it's bitter. Don, how would you interpret that?
Well, I would interpret that to mean sometimes it is because of the lack of opportunity that we may fight certain things. Yeah. Sometimes it may be lack of opportunity that we may fight some things. And I think in my context, I would tell you of our Kenyan normal practice in the political circles. We reject it before we are given that opportunity to have it. So we may, because lack may actually get to indicate what somebody really stands for.
Okay. Okay, how would you interpret that?
I would interpret it in twofold. First, this person does not have honey. Might be as he has ever tasted it, but because he doesn't have it, we don't want to make us believe that it is a bad thing just because he doesn't have it. The other way to interpret it, if he may not have tasted it, therefore, out of lack of knowledge, you would want to presume, just like the 5 blind men who are supposed to describe what an elephant is, each touches a different section of it. One touches the ear, thinks that an elephant is like a leaf. The other one touches the trunk, thinks it's a spear. The other one touches the leg and thinks that elephant is a big tree. So out of that lack of knowledge, you might end up coming up with the wrong conclusion.
Okay, interesting. All right, let's look at these 2 big words, defamation, libel. Before we even start to get to where then some of these things then, garner attention, what on earth do they really mean?
Under the, I believe the question is to me.
Let's see, yes.
That every person has a right to express their thoughts, but that right terminates where another person's reputation is on the line. So, under the Defamation Act, if you state something that is untrue, that and it's the same is publicized, and it ends up destroying someone else's reputation, that's defamation. Now, what is written, anything that is written in written form, or even in video, that is what is referred to as libel. But the other form of it is slander, where ile mushene, where people, by word of mouth, there is no print or video form of that which was publicized. That is what is called slander. Okay. All of it is now what is termed as defamation.
So slander is when we were just talking.
Yes.
Libel is when there is video or pictures.
Video or
there is no video or pictures.
There is video, there is pictures, or there is print form. You might have written a letter, an article about someone, and you ended up injuring their character, their reputation. Yeah, that's libel.
What if it's true?
Now, that's a defense. You would wait until you go to court.
No. What if the picture that I have, what if I have written an article about Susan? I've written something about Susan.
Yes.
Right? Susan had a baby with a man who is not her husband, who happens to be the husband of somebody else. And I have the birth certificate and all. It is true. Remember, this happens to be the case, and I write about it. What's libelous?
Now, one of the defenses available for a person who is, sued in a defamation case is the justification for truth. You can say, well, what I said, I stand by it. And I even have, say, if it's something you are alleging that someone got a child through an extramarital affair, that birth certificate would be a good defense. To say, well, it was not untrue after all.
So you can't sue somebody for libel if they have evidence.
If it is true
evidence.
And you have evidence.
Because truth and fact are not mutually exclusive. Truth could be true, but it is not fact. Fact also is in some cases will be different. So then if I have a fact that proves this truth, can I still be sued for libel?
Maybe you'll be sued for something different.
Or you can just leave me alone. You don't have to sue me because I have said the truth.
If you say that, Dons and I will go without food.
Oh, so we must look for something.
That's what I like to.
We must look for something to sue somebody for. Okay.
But there is also protection of your privacy under the Access to Information Act. So assuming, and the Constitution is very particular that you have a right not to have your personal details about your personal affair, your personal life, to be unnecessarily revealed.
Okay.
Assuming I have 30 children out there, you don't have to come and parade them here for all and sundry to see.
I don't think you'd have the time. But okay. Yeah.
Or the strength, though.
Yes.
Well, yeah, that's my take. Yeah.
So, no.
Yes.
So there is, this is a case where person X said this about person Y.
Yes.
So person Y then goes to court
Yes.
and sues for defamation.
Yes.
What are the thresholds for this suit? When you're suing this person, one of them, as Wakili Ndegwa said, is a reputation. Somebody's reputation, you've messed it up. How do you prove that a reputation has...
Now, it's very interesting how defamation cases nowadays take shape. First, there is an assumption that people make. I hope you've seen on social media that people think anything that is untrue is defamatory in nature. First, I must disabuse that. Defamation has about 4 facets for you to then reach a conclusion that certain sentiments were defamatory. The fact that they were false is just a facet of those 4. So, my brother has already told you, number 1, it has to be false. So whatever is true can never be defamatory. Secondly, it must be capable of tarnishing the reputation of another person. So that is the second aspect. And then the third aspect, it must have been given negligently or maliciously without cause. You just decided you want to destroy somebody's life.
Okay.
And on the fourth aspect, it must have been communicated to a third party. There is no defamation unless there is transmission of information. Now, you asked a very fundamental question. How, for instance, does somebody show that their reputation have been tarnished? Now, the Kenyan litigation of defamation has really transmuted. I would give you an example of one of the cases somewhere where a pastor was defamed online. He was able to get witnesses of people who outrightly wrote to him bad messages, out of that information that was flowing out. Why? Because they did not honor his reputation as they had interacted before. He was able to get statements, text messages from people who bashed him out of that, and he was even terminated by the conference where he was serving. The pastoral council decided to terminate him, take him on suspension pending the investigation. So it was building all this to show the court that in the process of what was going on, my reputation was tarnished in the process.
Oh, I get it. So the argument here is not whether the initial message is factual or not. The argument here is that as a result of the transmission of this information, there is some kind of harm that would have then been caused to the individual in question. So we're not even worrying about Susan and her promiscuity here. We are talking about the results of transmitting this information.
Exactly.
Is it true?
That is the whole purpose of defamation.
Okay.
And that is why truth is a defense. Now, I would come back to something. You gave an example. If somebody said maybe you had a child with somebody else and you have all the proof certificates and all this, if you can prove to the satisfaction of the court that this person had a child, that truth is a defense to what you said. So already one limb of how you prove defamation is down. So then the message will not be defamatory in nature.
But does it stop that this individual has been harmed as a result of that? It doesn't stop.
No, it doesn't. That's a separate question.
All right, okay.
You could go under privacy and say, my privacy has been violated, which is a completely different constitutional question. And by the way, many people now opt to go that route for the reason that if you go to court and ask the court to vindicate your rights, that either your privacy or human dignity, because what other jurisdictions like South Africa have done, they have said, they are making the argument that reputation cannot be disengaged from right to human dignity. So if you go to the Constitutional and Human Rights Division at Milimani today and file a petition that your human dignity has been violated, you will not be required to prove these 4 thresholds because defamation is civil in nature. But if you can take that defamation and trace its root in a constitutional provision, you will not even be required to show anything.
But Akil, here's the situation where, let me paint a picture where there is an incident that happened recently where there's this billionaire who was in a club, in a concert somewhere with another woman, and as you walk in, there is a poster. You're told, once you get in here, there is video and photography, and you seize your rights to privacy and all that. But you get in, a video goes up, and what happens at home is divorce proceedings start because you're seen with another woman and everything else. How then would you ever claim that your reputation has been injured if at all from the word go, you had waved away your rights to privacy?
First, let me respond to that. You have seen many instances where you get to a place and they say, photography is permitted, your videos will be taken. Unfortunately, the Office of the Data Protection Commissioner and the High Court has told us it is not sufficient to just put a notice somewhere and tell people, in here, there will be photography. Why? Because the courts have had a different thought process. That if you are making a notice that is to bind me, first somebody has to explain to me the repercussions of that notice. Just saying here there is photography, your videos may be taken is not sufficient. What is more is the resultant effect. If you take my video and post it on an online website, already there is a data protection question there. And this has happened to many schools in Nairobi, where a private school says they give kids some form and they sign, say, during your pendency of stay in school, your photography pictures may be taken. But they don't tell you for what purpose. So then they use them on the website, they use them on graduation posters. Courts have told us, no, it is not enough that you go to a club, you go to a parking area and you're just being told, don't park here at your own. Park at your own risk. What is the repercussion of that? It doesn't waive the responsibility the institution has to protect your privacy. That is the first question. So if I sue for defamation under such circumstances, will I succeed? My advice is that defamation would not be the best route because there is a data privacy question that, is first on board. But second reason why defamation would not likely succeed is because the video evidence is there. You were there with the woman, surely. So there's nothing false.
You've not heard people say it wasn't me. Anyway.
Yeah.
How do you prove, and I'm still looking, how do you prove, Wakili Ndegwa, that your reputation then was ruined? How can you prove something like that as a result of this thing? Because here we are still saying, like you said, Wakili Evans, that it's clear you were there. We saw the video, right? Yes. But how do I then prove that my reputation was soiled? Because it's not in contest whether I was there or not.
Yes.
What is in contest here, according to defamation rules, is that I suffered because of what you did. How can I prove that suffering actually took place?
It took place.
What does somebody's destroyed reputation look like?
Yeah, and I'm saying in answering that question, I have to take caution because ruining of a reputation is in abstract form. You cannot touch it. You may not be able to weigh it or value it. But courts have had a different. They have had a way to compensate, to value how much quantum ought to be paid for different people. Assuming you are a public figure, that which goes out there, you might not even have comments. Assuming this was something that was done on the print media, say in a newspaper, you might not have that feedback coming to you. But of course, someone may allege, in the course of my interaction, I had to confront these 1, 2, 3, 4 questions. It is generally an issue of the man at the omnibus would a right-thinking person take it that whatever was publicized about you would have injured your reputation? And that may vary. Say, assuming a pastor is seen, someone, a priest, is seen, engaging in the earthly pleasures. Whereas it might not sound as a bad thing. Assuming you find me taking alcohol somewhere, it might not be so injurious to me. I've not offended anyone. It doesn't go against the ethics of my profession. But for a pastor, assuming I publicize that I saw, Pastor Okari, assuming he's on today.
Yeah, but that's very apt.
Bless him.
That's very apt. Yeah.
I saw this coming.
I saw him, imbibing some holy waters of Cana of Galilee. It might have an injurious effect on him, but for me as a lawyer, the best I can do is probably claim against another concept of defamation called malicious falsehood, assuming it was not true. It may not be defamatory if the man at the omnibus, a common person out there, does not consider it as injurious. Assuming I get, it is rumored that I have taken in a second wife. Whereas in the African setting, that's considered as a show of wealth or a show of manhood. If my religion, and I'm a religious leader somewhere, then that is considered as injurious. But to the commoners out there, it might not be as injurious. There is different aspects to the quantifying what quantum ought to be applied to a particular case. It is not a one size fits all, and it applies on case per case basis, like the case I've just mentioned of Pastor Okari and a common practitioner of the law like myself. If both of us were to imbibe in the holy waters of Cana of Galilee, we would have different effects, such that now, depending on what ordinarily is called the man of the omnibus, what would they think of me? So you don't need to come with hard evidence of feedback from consumers of that information that was dispensed. All you just need to do is apply that rule of what would be a common man, a right-thinking person, other than our current politicians. What would they think of us?
Can I sorry to interject. Let's assume we are 1, 2, 3, 4, we're 5 of us here.
Yes.
And I start a story with a settle. So settle. There is this guy in a 3-piece suit in Spice FM. Me, the number of women I know. Yes, but I've not mentioned her name. I've not gone into a lot of details. I've just said somebody in a 3-piece suit.
At Spice FM.
Yes. And looking at all of us, you are the only one
with a 3-piece
suit. Can you then assume and say and sue that actually I was talking about you?
Absolutely.
But I never mentioned your name.
You don't really have to mention my name. There's even actually a different concept of it called defamation by juxtaposition. Now, what you've just mentioned is a satirical form of it. I'm trying to get the right adjective for it. Where you infer, you can make an inference.
Implied.
Yeah, you can imply, and the circumstances would directly mean that you are referring to me. Assuming today, we all know who the president of the republic is. If I come and say the president of this country has I might not have even mentioned his name. By the dint of that
Description.
The description, even caricature, I can create a cartoon that looks like you. Say this was you. You can defame without mentioning name. What now the claimant in the defamation suit will have to prove is that those defamatory statements were referring to him, and the burden is now up to the person who is claiming to show that the information that is in question referred to him. If, say, you are referring to someone at Spice FM, in a three-piece suit, would actually eliminate him, would eliminate her, would eliminate you. Then would be left with two people here. And if you move on to describe that he has a beard, definitely loosely, it means that you are. It's just the same thing that sometimes back someone said, "Mtu akiamka asubuhi bangi." People could almost tell who it is that he was referring to.
Yes.
Yeah.
But you see, so here's a question where, so there is everything that we're discussing, right? But then again, say if that is Pastor Kari was found imbibing the holy waters in the Cana of Galilee, and there is the aspect of right to information where one would say Okari's followers ought to know what is happening with Okari because we follow him, because we trust him. And someone goes down, pens something to describe exactly what Pastor Okari was doing. Where does it border? Where is the connection in terms of right to information that me as Okari's follower, I need to know what my pastor is doing, and departure from I'm defaming Okari?
Actually, that takes us to the next defense. There is something called a just comment, or a fair comment. Now, actually, before we get to that, I've remembered it's called defamation by innuendos. When you use terms that are descriptive of the person, but you don't refer to them by name. It's called defamation through innuendo. And especially this can even go to the kind of names. There are people we have branded names. If you say today you say Kasongo, we almost know who it is. But now back to the question that on the one that you've just raised, on the comparison between that is Okari and myself. Sorry, actually, just rephrase it. Just
the right to
context.
information.
Yes. When you are referring to someone who is a public figure, and information is, when you make yourself a public figure, say you step out in the political circles, or you are a pastor, or you are a leader somewhere, that necessarily does not waive your right to privacy, especially some aspects of it. You remember, for instance, public servants are required to declare their wealth. If you come and if you ask me how much I am worth today, I'll tell you it's none of your business. But if you are asking me about my former governor who was your guest today, my current governor who was your guest this morning, that's information that he has waived. That's a right he has waived by stepping up into the public service. And therefore, as one of the defenses in a claim for defamation, you can say this was a fair comment, assuming it is something that revolves around the spending of a public servant, about the conduct, something that touches on their integrity. I, as a Kenyan, I have a right to access that information, and I have a right to comment on it because it involves me. But any other thing about a citizen, and this is the wording of Article 35, is that any person has a right to access information held by the state being any person serving within the four arms of the government, and including the devolved structures. But any person, the second limb of it, that gives you the right to access information held by a private citizen, you have to justify it by showing that you need that information to access another right. Assuming it's something like, I want to know whether a certain lady, call her Susan, is married. I may need to know that so that I may want to exercise my right under Article 45 to maybe propose to her, betroth her. But otherwise, requiring for her to review that information out here to the public is actually an invasion to her privacy. Yes.
Well, actually, no. Somebody here was asking, what if the intent was humor? So what if you're making a joke and tie it in with somebody, Eric Ward is asking, if I say a setter puts on his father's clothes, can he sue me?
Now, quite a bit there. I think we've discussed so much. Now, on the humor bit works this way. The humor should not be one that injures the reputation. That is all. It doesn't matter what you intended, provided injury, the right thinking member of society can infer injury. And the question she asked is very fundamental. There are two things. How do you prove that there is reputational harm on you? How do you show that happens? Because there is no reputation. Reputation cannot be touched. We can't touch it and say now this reputation of somebody is injured. What the courts have been saying, especially when the limp of negligence or the malicious part has been proven, courts have then been asking, is the right thinking member of society listening to what this person is saying? Does this sound like humor or mockery? The line is very thin, but that is left to the courts. You would recall that during the height of the Finance Bill 2024, numbers for members of parliament were all out there.
Yes.
In fact, there was even a warning from the ODPC about data protection. Many members of parliament decided that, even warned that they're going to sue, Would such suit succeed if they were eventually filed?
Who would they sue? How many would they sue is the question.
Because, private citizens actually took the numbers and were sending them direct messages. Or even on Twitter, branded with images. Some were turned into dogs, some were turned into goats and all that.
And some in coffins.
Such would not succeed, I will tell you. Because of what he was trying to explain, the public interest element. It is not that those who get into public office waive that right of privacy. No. What the courts do is they weigh between that right and the public interest imperative and find out, in such circumstances, which of these rights hold sway. For instance, most of the numbers of the members of parliament are within the public website, the parliament website.
Yes.
So it would be very difficult for them to claim defamation or even data privacy violation. So as to mockery, as to humor, the question that one would ask is whether a right-thinking member of society would take this as humor or this would border the line of mockery.
What if the person wanted people to know the kind of individual that they're dealing with? This is just a question. What if, like I said, it's truthful, it's factual, this information that's being put out there. But of course, we've already established that, defamation is not going for the meat of it, but it's going for the periphery. That because of what you did, this is causing me harm. That's what defamation is all about. But what if the intent was for people to know, and it is based on truth and fact? I know that the data protection rules then come into play, but what if it was true? And it takes us to social media, especially on the X space, whereby a lot of this information comes out. You wake up in the morning and before you know it, it's 4:00. And by then you've heard already about 3 babies out of wedlock. You've heard of 3 people have cheated on their spouse and somebody has stolen money in a day. All of that has happened. And it's been put out there with the big word that we even hear is receipts.
Two clear examples.
With the receipts.
2 clear examples. This year, a blogger from Siaya County, twice, same person. One found liable for defamation, damages of 20 million. In the first case, what was he doing? He was attacking a member of county assembly on Facebook. And you see the information he actually put before, at the start of the post, he actually clearly states that the intention of this post is to raise awareness, expose fraud. He says a number of things there. And he says the husband of an unnamed woman has reached out to him. And he also says that in line of chapter 6, he wishes to do this expose, they say, so that the people of Zaya may see the shame that their MCA is and that their MCA may stop. That is the argument he made in court. The court said, no, the manner in which the information was dispensed and that part of malicious, whether there was negligent or malicious intent, is very critical in unraveling some of these lines that look blurred. The court actually found that he did not make certain steps. If he actually, the intention was that noble, the court asked the question, this is a public officer. Why would you not reach out to him privately first? He did not take certain steps that show he was not being malicious.
How could you possibly share such information without it having a dint of maliciousness? How could you do that? How would you possibly talk about in any manner something like that without it bearing the end result of being malicious? How can I say, oh, by the way, you know, this man has been walking around having an affair, but I wanted to sound as nice as possible? I mean,
No. It's actually possible because the court was saying if you are, there's something called good faith. Good faith is often inferred from how you handle such matters. Like he has said, if you seek information from a private citizen, you must issue a justification for such information. What do you justify such information to, as opposed to state information? State information you seek because you are a citizen. Article 35 simply says every citizen. But private information, you seek a justification. If you want to show the court you are not malicious, this is a member of parliament, the number is online, the Facebook page is online. What you would first do an inquiry. You will first do an inquiry. The court said he did not take certain steps to actually inquire or verify the information that is sought.
Let's take it a step further. What if this person, and journalists will do that a lot of times, what if this information has come, then I decide, okay, I'll make that call.
Yes.
Whether you pick the phone or not, it's still a story. So I'll still write that efforts to reach person X
Or futile.
You've defeated it.
Sorry?
You've eventually defeated the bad faith aspect. And I also wanted to comment on that in regard with another thing, fair comment. How does fair comment work? You would notice, and for journalists, you know this, that you would read stories. Most of these stories have been taken to court, or so-and-so reporter defamed me, and they don't eventually succeed. Largely is because the language is very careful. If you say that from the totality of evidence that I received as an investigative journalist, I think or I reached a conclusion that, you see, that becomes an opinion. It becomes fair comment. A fair comment. So if you made efforts, and you've seen that in a lot of documentaries, we made calls to so-and-so to respond before we published this story. They did not. So as you move to court, if somebody sues you, you would actually eventually show that you had good faith. You had good faith to give them an opportunity for a response if they so wished.
What if I say allegedly?
Yes.
We use that term a lot.
Allegedly.
Yes, that is also an opinion, because allegedly means you do not have a totality of the circumstances for you to certainly speak to the public and tell them this is the position. But your opinion holds sway one way or the other. It doesn't bind you as a person. Why? Because either you have said, in my opinion, in my analysis, or allegedly, having looked at all this, or I have seen also a new term. This raises questions as to corruption, blah, blah, blah. This raises eyebrows as to this. It's normally a big defense on the malicious
Kiroko,
part.
you see, most of the time, you would reach out as well, right? They pick up. But now one goes, Nini umeandika, do not, or I will sue you. That's their response to you requesting for a comment from them. Or most of the time, unadhani utafanya nini? So you publish. For all I care, there's nowhere you take me. Then later, after the story has gone, you've made your comment and everything, and there's traction to that story, then all of a sudden you find yourself in court. How do you go about it?
There's something that I like about the law and how it operates. There is something called a fair administrative action. Before I judge you, before I call you corrupt, before I say you are promiscuous or you're incompetent, I need to give you an opportunity, first of all, to give your version of events, your version of the story. So, assuming you've given me an opportunity, now if the shoe is in my feet, or my feet is in the shoe, you have given me an opportunity, and I have not have not counteracted
Utilized it, yes.
the information that you have. There is something called the doctrine of waiver. If, for instance, today I have a right to exercise a certain aspect of a remedy, but I don't until such a time when a decision is ripe to be delivered or this information is out here, then I want now to purport to give a defense when I already had that opportunity. Definitely, in the eyes of the law, you don't come with clean hands. You already have started with I'm not saying it's a conclusive defense that you are going to win in a claim of, again, in defending a claim of defamation. But once you are given an opportunity and you didn't utilize it, then the doctrine of waiver does not look at you with that kind of mercy. Again, there is something called an adverse inference. There is yet another doctrine called adverse inference. Assuming there is information that I have that is peculiar to me, if, say, information such as the number of wives I have, the amount of wealth I have, or if I own, assuming it's a business that is involved in, it's a company that is involved in some corruption deals, that is information that is peculiar to me, but I hide it. Then there is the doctrine of adverse inference. If I hide that information, it means that information is information that is against my interest, or rather against that which I would want for the public to believe. Yeah.
There's a question here about using these digital devices. And there was a story here about an increasing number of Kenyans who are being prosecuted and convicted because of sharing WhatsApp messages. There's an element when you're using WhatsApp where you forward messages. You receive a forwarded message, you also forward it to a group or to individuals. On X, there is reposting. So I'll see something that somebody has shared, and I will feel, okay, let me repost, retweet, or whatever. Can I be sued for a repost or for forwarding a message where somebody then will come and say, Dennis, you forwarded this message, therefore I'm suing you, but I'm not the originator of the message? How does it work? Okay.
Now, yes, you can, but under certain conditions. Republication, that would actually qualify to be republications of statements that are already defamatory in nature. But you would not just be sued simply for reposting. You would only be absolved if you can prove to the court that you were not reasonably aware that the statements, or from a look at them, you could not reasonably discern that those statements were defamatory in nature. That is the
How
only
do you
thing.
prove that? I can argue to the court and act a fool, and I can say, well,
It's just I normally forward everything.
I just repost, I forward everything I receive.
Now,
I think you also need to verify your source, because there is also something about misinformation. Assuming if it's an allegation of corruption coming from an Auditor General's report, and you repost it, whether it is not true or it is true, then that would be a ripe defense for you to use. But assuming it is a commoner like myself or a blogger somewhere seated talking about how promiscuous someone is, and you want to repost and still rely on that defense, you'll have a very hard time in court. There is something about reasonability. Would you ordinarily think, or would it be inferred correctly so that information coming from some quarters are true and they are verifiable? Okay, I don't.
Maybe it's a video. We do this all the time, especially on WhatsApp. It happens all the time where Ndu can send me a video of somebody. This person can be a prominent person. Maybe they were caught in some situation, and she shares it maybe in our WhatsApp group, and somebody maybe again I forward to another group. So if you come to find out that it is Dennis who forwarded this message to a certain group, can you sue me directly? But I'm not the originator of this message. I was just forwarding this video. That's what I want to know.
Yes, for
I can
me,
be
yes.
sued.
Yes, you can be sued. You know, the only challenge is that Kenyan legal system has not tested this, but India has. India has tested everything we want to know about the freedom of speech because of the large number of population that is there. And most jurisdiction, the argument has always been, were you reasonably aware? And the test, as you've said, is a thin test. But what I've seen also is, for instance, there are statements that could open room for different interpretations. If somebody says, coming 2027, I will finish you. Okay? There is a possibility that one party may think is referring to killing that person, and another party may think is talking about elections. You see? So in such a case, it will not be open. If Aseto reads such a case, Aseto will not reasonably know if this is defamatory. He may think one way or the other. So there are those statements that leave that leeway. You cannot reasonably discern from the look of them that they are defamatory, even if eventually the court finds that they are defamatory. But then they are explicit defamatory statements.
Wakili, let me throw something in the works. Fine. There's that question of, was I reasonably aware, knowing that this might dent me in one way or the other. Someone goes for a mental assessment and it is found they are not 100%. Can that hold in court?
Well, that is now what we call mental and legal capacity. That's a different question. Whether one can be sued
Or not.
or that's a different. That is capacity. For capacity is absolute.
Yeah.
If it is found that you have no capacity to stand trial, it doesn't matter what the contents of the matter.
But I'm curious because I always hear this thing from the courts.
Yes.
That somebody is taken to court, but then there is
A medical report.
a medical report.
Mental
So
assessment.
unaenda kuchunguzwa mentally. What does that even? What exactly happens? How are you testing somebody's? How do they do it?
It is sad for Kenya, and this is from my experience in not only criminal matters but civil matters. It's because today we have psychiatrists who would write a report you want. A report you want here. I have seen many people in the criminal justice system that have been declared unfit to stand trial, but they are fit 2 months after the matter has been closed. But the matter should come prima facie from the court, not from any party. It should not be one party alleging that I am unfit. The judge assessing either the accused person or a witness should be able to have some reasonable doubt that I think this man may not be okay based on how one-on-one questions are being. And this is normally done at the first instance when somebody is taken to court and he does not have an advocate. What normally the judge does is they try to engage you. And more often than not, if a judge tries to engage you and ask, what do you want to tell this court? And you begin saying, I sold my cows last Friday. Then quickly, they would decide, or they would ask parties to argue whether you're supposed to go for mental assessment. The sad bit of it, Dennis, is that it has been so compromised that even you today, if you want to be declared...
This is the Situation Room, the only way to start your day.